Today we have the honor of discussing constitutional law and family law with the Brown alumnus, Douglas NeJaime. He graduated Brown class 2000, went on to write a senior thesis in American civilization. Then he went on to attend Harvard Law School, and since then has become the Andy Professor of Law at Yale Law School, where he teaches in the areas of family law, legal ethics, law and sexuality, and constitutional law. Professor NeJaime, thanks so much for being here, and I'm excited to talk to you. Right off the bat, to get this started, let's talk about the Bostock case, and that's been a very controversial case ever since the decision came out. It was a little bit over a year ago in June. But before we get into that, could you kind of explain what contextually prompted the Title VII of the 1964 Civil Rights Act, and sort of what was the purpose behind that legislation originally?
Yes, so the Civil Rights Act is sort of the major piece of anti-discrimination legislation by Congress in the second half of the 20th century, and Title VII regulates employment discrimination. So it prohibits discrimination in employment based on a number of characteristics, one of which is sex. And so the main question going forward was, what does it mean to discriminate based on sex? And that has had a lot of different dimensions to it, but the one that Bostock raises is, does that include sexual orientation and gender identity?
Right. At the time, that was much more oriented towards purely sex discrimination rather than gender rule, rather than like the sort of transgender things that we've been dealing with for the last 15, 20 years.
Yeah, I mean, the thing that's remarkable to me about the Bostock decision is that it acts as if sex meant what we think it means today, that it meant that at the time. If you actually look at the history right after the enactment of Title VII's prohibition on sex discrimination, the EEOC, which is the main agency that does employment discrimination work for the federal government, was actually saying that sex segregated job ads didn't violate Title VII, meaning you could say secretary ads for women and janitor ads for men. And of course, we would say that's clearly sex discrimination. So our understanding of what sex discrimination is was not stable at that time and continues to evolve. And so certainly at the time, people did not understand a prohibition on sex discrimination to necessarily reach discrimination against lesbian, gay, and transgender people.
Is that partially, you think, just because the whole idea of transgender people and things like that were just simply less common at the time, so it's not something the lawmakers really took into account?
Well, it's interesting. I mean, certainly, yes, but I also have zero faith that if lawmakers took it into account, they would have thought they wanted to prohibit discrimination on that basis. I mean, one thing that's just changed dramatically since the 1964 Civil Rights Act is that our understanding of whether discriminating against lesbian and gay people or transgender people, whether that's appropriate, has just changed so dramatically that we now think, well, it's not permissible to engage in that discrimination. And so our laws must cover that sort of discrimination. And at the time, not only was it much less understood, discussed, acknowledged sexual orientation and gender identity as a category, but also there was widespread belief that discrimination on that basis was not only okay, but probably, good.
And essentially what you're saying is it's not simply that they didn't take it into account, it's that even if they did take it into account, they were likely to sort of slight that demographic of people, right?
Yeah, I mean, this was at a time when the criminal law still prohibited same-sex sex, when openly gay people would not be able to keep a job in the civil service. Those things were being challenged, and it was a huge uphill battle. So it certainly wasn't a time where Congress had any appetite to prohibit discrimination on that basis.
Right. So before I really ask you about the Bostock case, I'm just curious, as being that you're a faculty member, what is your sense of sort of the divided opinion within academia about this case? Because I can imagine a little bit what your view on this case might be.
Yeah.
I'm just curious, within academia, especially where you are, is there a wide range of opinion, or is this something that your colleagues come down pretty squarely on.
So I think there's general consensus that Title VII's prohibition on sex discrimination should be read to cover sexual orientation and gender identity, though I think there's probably more consensus around gender identity than sexual orientation. I think where the real debate is the way that you get there. And so, the opinion for the court by Justice Gorsuch is taken to be a textualist opinion. And there's a lot of other opinions before Bostock in which lower courts are getting to the same conclusion, but they're doing so by talking about legislative purpose or by reasoning about sex stereotyping. There's other ways you can get there. And I think that's actually where most of the disagreement is, because, if you actually look in the case, there were amicus briefs filed by conservative law professors supporting the interpretation that the court reaches.
Right. So in other words, you think there might be more of a consensus on the outcome as opposed to how they reason to the outcome?
Yes, exactly.
So could you sort of just unpack the basic reasoning behind the court's majority opinion in Bostock, and in particular at some point, could you just try to explain, especially for undergrads, it's really difficult to understand what Gorsuch meant by the whole but-for causation, and he kind of really makes a point of emphasizing that in his decision, which really makes him almost seem like more of a philosopher than a jurist sometimes. But if you could just talk about that.
Yeah. So I guess let me take a step back and say that there were lots of grounds on which people were arguing that Title VII should be read to prohibit discrimination against LGBT employees. And one ground is that on a sort of what people say is a textualist, straightforward textualist reading, that the statute itself prohibits discrimination based on sex, and regardless of what legislators thought they were doing or intended to do, the language itself covers discrimination based on sexual orientation and gender identity. And so in anti-discrimination law, causation is important. So there's this idea of but-for causation, which is the idea that but for this thing, this other thing would not have happened. So in anti-discrimination law, but for the employee's protected characteristic, sex, their termination or demotion or not being hired, whatever the adverse action, would not have happened.
Right.
And so, so Justice Gorsuch is saying that but for the sex of the employee, they would not be in the position that they found themselves in. And so if you think about a gay or lesbian employee, if a employee were to have a partner who's a woman, whether that person is discriminated against might depend on whether the employee is a man or a woman. And so the sex of the employee is a but-for cause. It doesn't need to be the only contributing factor, but if it's a but-for cause of the adverse employment action. For a transgender employee, someone presenting as a woman, one person, you had two employees presenting as women, one is fired and one is retained. If one was assigned male at birth and the other female at birth, but for the sex, the person assigned at birth, the adverse employment action wouldn't have been taken. And so therefore, discriminating against someone based on their transgender status or based on their sexual minority status is necessarily sex discrimination. Now, you can get to that reasoning without saying that you're doing textualism. You can just reason about anti-discrimination law. Another popular way in which people were reasoning about this question was to say that discrimination against LGBT people is based on stereotypes about sex, that quote, real men and women should look, act, behave a particular way. And trans employees and gay and lesbian employees don't conform to the stereotype. And there's a really foundational Supreme Court decision called Hopkins versus Price Waterhouse, in which a woman accountant was not promoted to partner at Price Waterhouse And in her employment record, there were a lot of comments like she should dress more femininely, act more femininely, wear pearls, put on makeup. And the court decided that that was discrimination based on sex under Title VII because she was being essentially punished for not conforming to ideas about what a quote real woman should look like and act like in the workplace. And that's been extended to gay and lesbian employees and trans employees, but the court in Bostock doesn't go that road.
Right. Yeah, it's interesting. I've not heard the latter sort of argument that you just made about stereotypes. It's interesting. Especially, I mean, essentially, my understanding of the but-for causation is that it's Gorsuch's way of avoiding criticism from the originalist camp, essentially, right? By using that he's working within the confines of textualism, using this principle of it's an indirect cause of their discrimination is their sex. It might be the first cause, but not the surface level cause, right? Because surface level people are going to say, oh well, it's that they're transgender and that's why they're being discriminated against. But Gorsuch is saying, well, their sexual orientation hinges on their actual sex, and sex was the understood purpose behind the original act, right? So as long as he can connect that line between, give birth sex to how they're being discriminated, then it technically works within the framework of textualism, right?
Well, interestingly, he doesn't really care about original purpose because he's sort of saying, well, our job as judges is just to interpret the statutory text that's been put before us. So the textualist would say, the really nice thing about textualism is that it allows us to objectively analyze a statute without our policy preferences, our substantive judgments, and not having to discern what legislators' purpose was. And so instead, we just have this word. And if the legislators wanted to have it mean something different, they should have done that. But they didn't, and this is what the word is. And so we're just going to interpret that word and apply it in this context. And what's fascinating to me about the fact that, I mean, if you read the majority and then you read the dissents, they're all saying they're textualists, right?
Right.
So what's fascinating is, textualism doesn't actually seem to be so objective and leading in this one direction, because both the majority and the dissents are reasoning in a way that just shows that everything that's happened over the past decades is relevant to how we think about these questions. And so it's just implausible to me that Justice Gorsuch can interpret the statute in the way he's interpreting it and purporting to be doing nothing more than doing what the statute means in 1964, when it is implausible to think that the intervening decades of all of this conflict over whether LGBT people should be treated as full members of the society and whether they're, deserving of equality, that all of those conflicts haven't shaped the way that we answer the question in 2020. Of course it does.
Interestingly enough, I guess, Gorsuch, this might be his single most scrutinized decision, at least in recent memory. I think arguably most of that scrutiny comes from, guys like Alito and Kavanaugh, who claim to, kind of be the real textualists or the real originalists, whereas Gorsuch is kind of departing on his own, perhaps like partisan path by doing this. That's sort of like the most cynical possible interpretation of how he came down on this case. But how do you respond to Alito and Kavanaugh on the ruling of this case? So Alito said that Congress has for many years considered but failed to pass bills to add sexual orientation or gender identity to Title VII's list of protected categories, implying that this is essentially judicial activism at play here. And then Kavanaugh sort of piggybacks as a dissent and says, the question of whether to add sexual orientation and gender identity to Title VII rests with Congress and the president, not the court.
So, I mean, they're just talking about different things. Like the question that Alito and Kavanaugh are putting on the table is, should we actually say that the statute includes sexual orientation and gender identity? Which of course is not what Justice Gorsuch is saying. He's instead saying the category sex includes sexual orientation and gender identity, which is an argument that's been around for decades. And that's why I say people actually, there's more consensus around gender identity than sexual orientation, because even as a constitutional matter, so for instance, the 11th Circuit Court of Appeals, in an opinion joined by Judge Pryor, who's one of the most conservative judges, says that discrimination against a transgender employee who's a government employee, so the Constitution applies, is sex discrimination under the Equal Protection Clause, because gender identity is sex. Right. And so that's that argument has been around there. The Kavanaugh argument is an argument about sort of the role of the court. The argument is a bit harder to make in this legislative context where all the majority is doing is interpreting a statute that Congress has passed. The Justice Alito point, I think, is actually one that I don't credit at all, because there's been a long history of whether courts should take into account, are you supposed to draw a negative inference from a legislature not doing something? And most judges have said, no, there's all sorts of reasons why look at Congress right now. There's all sorts of reasons why legislatures don't do things or get things passed, which has nothing to do with their views of the underlying merits. And actually, one counter explanation for why Congress didn't do anything is that the courts were interpreting it to apply, and so they thought it already applied. So there's that, I think, to me, is not a very good argument. The Kavanaugh argument is one about whether it actually takes you back to the ultimate question of whether you think the statute includes this or doesn't include this as it exists now.
Right. So if I'm understanding that correctly, it's essentially, I think that's really counterintuitive reasoning you just gave there, which is, I think that's pretty persuasive. The way that you said that the real reason why this legislation modifying or adding to our understanding of Title VII, perhaps the real reason why that hasn't succeeded isn't because it's not popular with voters or popular, a popular idea within culture. It might just be because there's some sort of dysfunction with our legislature, as is very obvious nowadays. There's a lot of things that a lot of Americans agree on, and we still can't get bills passed for it, right?
Right.
So it's partially that, I think you're saying, and then I think you're also saying that even if it's not that, it might just be the fact that courts are already implicitly assuming that these principles apply anyways. So therefore, why explicitly legislate something that you already think applies, right?
Right. So the analogous in the equal protection context, an analogous example is the coverage of sex discrimination to cover discrimination against women. There's, Congress was trying to pass the ERA, and then you get what scholars have called the de facto ERA through judicial interpretation of the Equal Protection Clause. So then Congress might feel like it doesn't need to pass an ERA. So there's just all sorts of explanations. So I think Justice Alito is too quick to say that this must mean this.
And do you think that, I'm just curious, because I've never really heard from law professors like you about this. I mean, this is pure speculation, but do you think he really believes what he's saying on that? Or do you think that's more of a straw man, like to frame the argument in a way that makes it seem implausible? Because
it's a great question. This is why I think textualism across the opinions sort of shows itself as not immune to dynamic interpretation and policy preferences and substantive judgments, because Justice Alito's textualist analysis is, underpinned by a lot of his substantive judgments, which is, he really does not he views sexual orientation and gender identity anti-discrimination protections as a threat to religious liberty, and is not a fan. Even if legislatures are going to pass them, I guarantee you he is going to vote to limit them in various ways. And so his own substantive views are clearly shaping his interpretation of what the statute must mean and what Congress really did, in a way that I think we should all just be more open about it and sort of say that, of course, our substantive views are shaping how we approach these questions, and everyone's fighting over these substantive views. And so to pretend we're just sitting in 1964 and deciding this question in this really sterile way just seems not accurate to me.
Which all goes to say that jurists in general have biases, regardless of whether they claim to be textualists or you name it, right? They have inevitable biases where they might try to limit it to the best extent they can. But inevitably some of that is going to show at some point or another, right?
Yeah, so there's a colleague of mine who's at UCLA, Carrie Franklin, who talked about living textualism. There's living constitutionalism, and then my colleague Jack Balkin has living originalism, and then there's originalism, and there's textualism, and she says Bostock is living textualism, which is just that it's impossible. So if these were easy questions that you could just solve by saying this word means X, it would never get to the Supreme Court. And so the fact that this is getting to the Supreme Court means we're all disagreeing about it, and we all have substantive views that shape how we assess the question. And they shape in part like the tools that we choose to analyze. But I think her point is, to the extent that people think of textualism as conservative and originalism as conservative, there's not something inherently conservative about the methodologies, and they're not removed from politics and from substantive judgments in the way that they purport to be.
Right. And we have to talk about what Alito said during oral argument. A lot of people focus on this sort of hypothetical that he gave. He said, imagine that the decision maker in a particular case is behind a so-called veil of ignorance, and the subordinate who has reviewed the candidate for a position says, I'm going to tell you two things about the candidate. One, they're the best candidate for the job. And two, this candidate is attracted to members of the same sex. So in this hypothetical, if the employer responds and says, okay, well, I'm not going to hire this person for that reason, that they're attracted to members of the same sex, is that discrimination on the basis of sex, despite the fact that the employer does not actually know the sex of the individual involved?
Right. So, I think that's a really good hypothetical to put forward. It actually, for me, shows why this kind of reasoning, like the reasoning that Justice Gorsuch is engaged in, is not, for me, the best way to reason about these questions. My head starts to spin when I read Justice Gorsuch going through the but-fors and using different examples. And Alito's, to the extent you can read that statement from Justice Alito as a response to some of that, it's persuasive to a certain extent. So of course you can have a response to say, oh, well, it's still based on sex because it's based on having an idea that the person is interested in people of the same sex rather than different sex. So you can't get there without having some idea of sex. But that's not how, I would respond by saying it's actually completely without context and misses the social meaning of sex and gender, which is like in the workplace, discrimination against people because they're gay or lesbian is, in my view, bound up in views about how men and women are supposed to be and act, and who they're supposed to marry and who they're supposed to date and who they're supposed to have sex with. And so this inability to conform to stereotypes about what real men and women are like is the basis of the discrimination, which would moot Justice Alito's question. But I think and actually say, well, let's think about how this works in the real world. But within the kind of textualist confines that Justice Gorsuch sets out, I think Justice Alito has a very persuasive response.
Right. So it's almost like, if I'm characterizing that description accurately, it's that you find it a little too abstract and almost it's a little bit unrealistic just to even posit that as a hypothetical, because for something to be a matter of law that would come before a court, it's the court's job to understand all the relevant context, right? So
yeah, there's real people here who were discriminated against, and like, what are the facts? But I actually, for all the things I might fault Justice Alito for, he's responding to the way Justice Gorsuch is reasoning about the question. You can read Justice Gorsuch's opinion and have no idea that for 50 years, people have been fighting over the inclusion of gay and lesbian people and trans people in employment and what language means. You could just not have any idea because there's no sense of the real stakes and who's actually harmed by discrimination.
Right. So just, again, probably too abstract for it to really be, It's persuasive in its abstract, but it's just, the law is far too contextual and realistic to rely on something that abstract. Yeah.
Yes, that's what I think.
Last question on Justice Alito and his relevance to this case, which is that, as you've alluded to earlier, it is publicly known his views on religious liberty to some extent, because he's spoken actually in pretty good detail about his view on the Little Sisters of the Poor in one instance, and then he's
I
also
listened to his FedSoc speech from last year.
that's right. So did I. His affinity for the protection of religious liberty, particularly religious liberty for minorities or minorities of faith, is something that's publicly known. From a sort of 5,000-foot view, since this case of Bostock has been rendered, about a year later, we had the Fulton County case and holding, which held that it was essentially a short-term win for religious liberty, but it wasn't the sort of overturning of Smith that Justice Alito wanted. How do you view this Bostock case as something that kind of affects the extent to which LGBTQ people can enjoy non-discrimination protection, and it's something that is somewhat in tension with religious liberty in that way, because we might eventually use LGBTQ and sexual orientation as somewhat of some religious exemption claim. So if you see how he's so much in favor of these protection for religious minorities, we might struggle to understand why at the same time he's not willing to extend that same protection for minorities to this group, right?
Yeah, I mean, I think that's perfectly said. If you look at the way that Justice Alito reasons about discrimination in the religion context, it looks very different than the way he's reasoning about discrimination in the minority protective equal protection context. And it used to be the case, if you look at a case like Smith, Smith was written by Justice Scalia, and equal protection law and free exercise law were sort of traveling together. And part of why Justice Scalia said, neutral and generally applicable laws should get only minimal constitutional scrutiny under the free exercise clause is because he didn't like disparate impact causes of action, meaning a discrimination claim based on the impact of a law being disproportionate rather than there being a facially discriminatory law. And he was doing the same thing in equal protection. And now Justice Alito and some of the others are making the free exercise claims essentially disparate impact claims. And even without overturning Smith, they've been able to really do that. But in the equal protection context, they are very hostile to those kinds of arguments.
Right. So you do see somewhat of an inconsistency in his willingness to extend sort of 14th Amendment equal protection to those two groups.
Yeah, I think that's completely right.
And before we get into your career questions, I read a little bit about your work on sort of first identifying the different statuses that different families have under the law. And I think a lot of that sort of delineation of who enjoys more status than others is, it's certainly something I haven't really noticed, and it's something that reading about really highlighted to me. Could you talk a little bit about your work in highlighting those discrepancies and fighting for equal protection for all families?
Yes, great. So yeah, a lot of my work now, both my research and writing, but also like the extent I'm doing advocacy, have been in the family law space and really trying to get people to see that there's a lot of families in which people are parenting children to whom they're not genetically related. And that happens because people use assisted reproduction. It happens because people end up being in parent-child relationships after a child's birth. And people are step parenting and they become the parent of a child. But a lot of those folks don't actually have legal recognition for their parent-child relationship. And that presents a whole host of challenges, including for the child, because children do better when their parent-child relationships are legally secure and stable. And so part of what I've tried to do is to show people, even though people have an intuition that parent-child relationships are biological or genetic, that in fact, we have a long history of that not being the case. And it has tended to be that we've recognized non-biological parent-child relationships when they're formed by different sex married couples. And we've tended to be more willing to treat men as non-biological parents, especially when they're married to a birth mother. And for same-sex couples, they necessarily include a non-genetic parent. And so any system of parental recognition that's going to really treat same-sex couples as truly belonging has to have paths to recognition for non-biological parents, not just inside of marriage, but outside of marriage, that do not require a formal step like adoption. And so a lot of people are adopting their own children. Many same-sex couples engage in an adoption that is essentially adopting the child they're raising, because that's the only way for them to get legal status. And so states need to pass laws that actually recognize parent-child relationships based on things other than marriage, adoption, and biology. And Rhode Island and Connecticut have been two of the leaders on this. So Rhode Island passed a comprehensive parentage law in 2019 that took effect in 2020, and Connecticut did in 2020 that'll take effect in 2021, that says essentially that when people consent to assisted reproduction with the intent to be a parent, they should be treated as a parent. And when they're parenting a child for an extended period of time and the child views them as a parent and they hold themselves out as a parent, we should treat them as a parent. And that's really a way to protect children's relationships with the people who are doing the incredibly difficult work of parenting them.
It all goes to say that it's best for everyone, not just the kids, but really broadly speaking, society in general, if there's a wider, broader understanding of what the family constitutes, because that way, kind of no matter who the children rely on, that relationship will have legal protection, and therefore the kids are more likely to succeed, and probably the parents are more likely to be able to support their kids at the same time. Is that accurate?
Yeah, so I mean, my view of it is our world is actually full of a lot of different families, and people form families all sorts of ways, and that our law should recognize those families, because if they do, then everyone's going to be more stable and secure. And there's a lot of research on, I work with colleagues at the Child Study Center at Yale, there's a lot of research on child development that basically shows that if children have secure parent-child relationships, if they're secured to the person who's actually parenting them, that's going to bring a whole host of benefits. It also makes them eligible for things like health insurance from that parent, things that they really need for their well-being.
What's flawed about the system now? Is it that the traditional family structure of just, a biological father and mother, especially mother, is protected at the cost of any sort of more tenuous relationship between parents?
Yeah, so the main problem now is that if you are a non-biological parent, whether that's because you did assisted reproduction or not, you are much less likely to be legally treated as a parent. And in some states, you might not have any path to have your legal relationship recognized. But in some states you can with adoption, which of course costs money and takes time. The problem is even worse when you end up with cases in which someone's been parenting a child for, let's say, 10 years, and the other parent dies. And the question is, who's the parent of that child? And then suddenly a genetic parent swoops in who hasn't had any relationship with the child and has a superior right to custody over that child than the non-biological parent. And that's just bad for children, to sort of take them out of the only home they've ever known and put them with what is essentially a stranger, but happens to be a genetic parent.
It's really interesting. Yeah, I'm gonna link your paper on. I at least read
Great.
one of your papers on that. I'll link it to the description, so
Thank you.
students can check that out. So now let's talk a little bit about your career post-Brown. Just, it's our understanding that you received a prize in American civilization for your thesis. Is that accurate?
Yeah.
Yeah, and so a thesis is something that a lot of seniors, especially, I mean, that's popular discussion among seniors because everybody's sort of writing their own. But
Yeah.
At the end of the day, we all sort of wonder how important it is for an aspiring law student to write a thesis. And we're just curious if you have any thoughts about that.
Yeah, so I mean, I really enjoyed it, but I also enjoyed research and writing, and also had a sense that I wanted to be an academic. So it, for me, was an important exercise. I think it's always a good exercise to just think deeply about one problem and write about it. And certainly law school is going to present that. And if you, at many law schools, I know at least at Harvard and at Yale, students must do a pretty large scale research project by their end of their third year. And so a thesis is in some ways, I think, good preparation for thinking about that kind of project. So for aspiring law students, I think it's of course not necessary, but it sort of gets you good practice at thinking extensively about a problem and writing about it.
That's more or less what I expected, how you'd react to that, because I mean, especially if you're truly intending to practice law, or I mean, being a professor might even be more so of this, but if you're truly intending to practice law, that's going to be a very, there's a lot of tedious elements of that, that are obviously very different than sort of the quick aspects of the LSAT that you're tested on, right? So if you really want to embark on a career that's really devoted to a lot of analysis and attention to close detail, it sounds like you'd be pretty well served in practicing that skill and researching as best you can as an undergrad, right?
Yeah, researching and writing are key to any legal career, and detail is also critical.
Right. And so right after after the submission of that thesis, you went on to Harvard Law School, where did you have any, I guess first we'd like to know just what you were thinking upon entrance to law school, if you had if you were already thinking about being a professor, it sounds like, but and then furthermore, what do you think about your habits at Harvard Law School made you so successful there?
Yeah. So I was interested in being an academic, and my MCiv concentration my thesis was written through the English department, and I was thinking about PhD programs. And my father ran a liquor store his whole life and didn't go to college. And when I said that I was thinking about a PhD program, he sort of lost his mind and just thought, you're not going to school for another 7 years and making less money than I made running a liquor store, which I don't know how true any of that is, but I was an obedient son who said, okay, I'm also thinking about JD programs. And I also was interested in having effects in the world, and law professors are able to sort of be in the world and also be in the academy. And so that really shaped my thinking about pursuing the JD. And then when I got to Harvard, I mean, in some ways it was so unlike Brown that it was shocking to me. And I was there before Elena Kagan had become the dean. And when she became the dean, she changed the school in various ways to make it I think, warmer environment. Like, I was there and my classes were 200 people, and we had, it was just pretty, it was just a big place that could be kind of alienating. But I really ended up sort of attaching myself to a couple of professors who became mentors. And I think for me, the biggest thing was that
Who were they, by the way?
Janet Halley, who is still there on the faculty, very senior, and Lonnie Guinier, who is now in nursing home care. And we're actually doing she's a Yale Law School graduate, and we're doing a big conference tribute for her Saturday. But she was wonderful when I was there. And her son is actually now on the Harvard Law School faculty. And I sort of took their classes and wrote papers with them. And I did my third year paper as a sort of early academic paper where I published it as a comment or a note. And for me, law school there's lots of different things to get involved with. And because I sort of knew I was interested in being an academic, I really focused on coursework and writing. And so I truly didn't overextend myself into student activities and things that were going to take time but not be towards my end goal. And I was kind of like that at Brown too.
Did you do any clinics in law school?
I did. So at the time, Harvard also had many fewer clinics than it has now. And so they were more structured around externships. So I did an externship at GLAAD, which is an LGBT legal organization in Boston. And I worked there in the summer as well and loved it.
So that's what you did in between law school?
My first summer, in between first year and second year, I worked at GLAAD. And then my second summer, I worked at a law firm in LA called Irell and Manella, that at the time was doing it was a private firm, and I ended up working there for 4 years and did a lot of IP litigation, but they also did a lot of LGBT pro bono work.
Mm-hmm. And while you were doing that litigation for that firm, did you still maintain the intention the whole time that you were eventually going to be a professor?
That was my hope. Yeah. So I litigated, actually, the argument I was making to you before about sex stereotyping and sexual orientation discrimination. was what I did in litigation. We represented women's rights organizations in the same-sex marriage cases because I went to law firm right after, the Massachusetts Supreme Judicial Court same-sex marriage decision came out like my second month at the law firm. So there ended up being all these cases around the country, and we made the sex stereotyping argument. And I ended up doing that with a co-counsel at the now Legal Defense and Education Fund. And she and I ended up writing an article together on the work we were doing that we published because we both were interested in being academics. And so I kept my eye on that, even though I didn't have a lot of time. I managed to sort of use the work I was doing in practice as a basis for a law review article. And then I applied to fellowships and went to the Williams Institute. And I actually did pro bono work for the Williams Institute while I was a lawyer. So I built a relationship with them. And they then were the organization that I was working for when I went on the academic job market.
Right. And would you say that you still retain that sort of dual personality of being on one hand an academic and on one side you're still a practicing lawyer?
So more so than most of my colleagues, yeah. So I still do, I'm pretty involved with litigation around the country on the parent-child stuff I talked about. And I do draft amicus briefs to file in cases and, lead legislative, like I did a clinic at Yale to do the legislation on parent-child stuff, even though I'm not a clinician, because I was gonna do it anyway. So I definitely have sort of a foot in that world in a way some of my colleagues maybe don't.
Right. Is there any book or movie, I'm assuming probably some sort of writing that really influenced the trajectory of your career? Or maybe someone you look up to in the legal world that's always kind of been a guiding force for you?
Yeah, I mean, I'll say so Lonnie Grenier and Janet Halley, who were my two mentors, what was amazing about them is that my interests were sort of right at the intersection of their work, because Janet is a queer theory scholar who's really interested in sexuality and gender, but from a very left critical perspective, like deconstructivist. And Lonnie Grenier is like in the trenches. She worked at the NAACP Legal Defense Fund and did a ton of voting rights legislation and was eventually nominated to be the Assistant Attorney General for Civil Rights in the Clinton administration before that was derailed in a political fight. And so she was very much about like, how do lawyers represent movements, and how do we do this work of, bringing about a more just world? And the two of them together sort of nurtured my interest in critical sexuality and gender work and also representing movements. And so their work, like Janet she wrote an amazing book on the Don't Ask, Don't Tell military policy that was sort of a polemic against the policy, but not from the perspective of like gay rights, but instead from the perspective of it's policing everyone's encounters in ways that are really toxic for an environment in which people live together and work together. And Lonnie had written books and articles about her, rise to being nominated to Assistant Attorney General and doing voting rights litigation and how to bring voice to people who are voiceless. And that influenced me in a way very different. So they both sort of influenced my own thinking and continue to this day.
Right. And perhaps it's also been fortunate for you in the sense that, this is a really, I guess, exciting area of law that still has a lot of work to be done. Right. Whereas, because I've heard from my advisor, at least at Brown, it specializes in constitutional law and things like that. And I know that at least, generally speaking, constitutional law, strict constitutional law, not necessarily pertaining to 14th Amendment, things like that, but just strict constitutional law is a very saturated market, shall we say, whereas I think some of what you're doing is more of an open field where it's probably exciting for you to be on the front lines of that, right?
Yeah, I think that's definitely true. I mean, when I went to law school, Bowers versus Hardwick, which is the Supreme Court case saying that criminalization of same-sex sex is constitutional, was still the law of the land. I mean, that's what I was taught in school. So it was a place in which there just weren't many people working on it. And as I came of age, it became much more acceptable to work on these questions, and you could actually get a job working on these questions, where for a generation ago, you weren't going to get a job if you were doing this stuff.
Right, exactly. So And then that leads us to our last question, which is that, there's within any university, there are kids that aspire to go to law school, but they probably have a much less developed idea of what they want to do than you did. And some of our students are not even sure that they would ever really want to practice law, even despite aiming for a law degree. Could you just touch a little bit on what your casual pitch for why someone ought to go to law school is?
Yeah, so I mean, I do think in many ways, law school can be the most general of a graduate degree, and leave you with the most options for what you can do afterwards. And I see this in my students all the time, that they go on to do all sorts of things. Many of them, of course, become practicing lawyers, but many of them go on to do policy work. Many of them are running for public office. Many of them are leading nonprofits in which their legal skills are important and they understand how to analyze legal problems and think about legal change strategies, but they're not, quote, lawyering in the traditional sense. I think especially at a place like Yale, because you can really craft your curriculum right after the first semester, you can take all sorts of classes that aren't sort of black letter law classes and explore different subjects that you're interested in, and then go out and have whatever career you might want to have. And part of that is sort of learning about what people are doing that you find interesting and hearing about how those people got to where they are. But I think law school gives you those opportunities to interact with people who have a law degree and are doing something that you find really interesting, and you're not quite sure how you get from that where you are now to that point. And law school may be one way to do that. You might also find that you just are much more interested in a particular area of law that you never thought of, and so maybe you do have a traditional legal practice, but just doing something you never really thought you were interested in.
Right. So law school can be a springboard for a lot of options. And just to quickly clarify, you ended up choosing against going on to do a PhD, right? And
Yeah.
What's your general advice for people that are sort of in the same sort of balancing those same two options?
So I will say the legal market, for people who want to be academics, there are now so many joint JD PhDs on the market. And in one way, that suggests that a PhD is becoming almost like a requirement. But in other ways, it suggests it's becoming so common that it's not actually distinguishing people. The other route, which is the one I went, is a fellowship, a 2-year fellowship that allows you to write and teach at a law school and puts you on the job market, which when I did them, there were very few, but now they've become very common. So I do think a PhD is a good thing to do for someone who wants to have the methodological skills that a particular field offers that law doesn't. Like, you want to be able to do law and economics and you want the tools that economists have. But if you're just generally interested in law, I don't view a PhD as a requirement. And I think you can get a fellowship that helps you go on the teaching market in law in lieu of getting a PhD.
Right. It looks like that wraps it up. Thanks so much, Professor NeJaime, for joining me today. We really appreciate the opportunity to talk to you and discuss some of these ideas with you. And we'll link his email in the bottom of the video in case anybody's looking to get in touch with him. Thanks so much again. We'll be in touch.